Okay, I'm going to start with the name of my talk is Pathways to Innovation. Let me tell you just a little bit about myself. I went to Worcester Polytech. I graduated in 1985. I did my MQP in robotics. I interfaced to robots. I also worked on campus at the materials testing lab. I was the first student to open up the Instron lab downstairs with Professor Barron back in 1984 or so. I decided to do something a little bit different back then. I decided to go to law school, and I went right out of WPI. And an interesting point about my career is I spent the first 9 years of my career in general practice. And I handled all kinds of different matters, a lot of car accident cases, construction accidents. I think I worked on 5 electrocution cases. And I've hired many WPI professors as expert witnesses. There was a gentleman, Ray Haglin, who was an excellent guy. I had him as an expert witness in a van rollover case. He's one of the individuals who got me interested in law school and engineering. And then I've also hired Professor Sisson, and I think I've hired Professor Barron. I might have even asked you at one point on something. But I've had a nice warm relationship with the professors here. I serve on the ME Advisory Board. And I also have had a lot of interactions with professors around the country in different disciplines. So my firm is based out of Hartford. We have 5 offices. We are the 7th ranked IP firm for patents applied for in the country. And we're ranked 20th for trademarks. So with that in mind, I was sitting in your seat too long ago, but I know what it's like to be a student and trying to get projects done. I think you're all going to be happy you went to WPI. All my colleagues and roommates did quite well. And I think the MQP process is a good one. So I'd like to talk a little bit about pathways to innovation, because one thing that I see on a regular basis, obviously as a patent attorney, is inventions coming in the door. And I chair my firm's litigation department. So I'm the person that tries these matters to courts, and I can find problems with patents, and I can help keep bad patents in force, I hope, sometimes. But there are ways that people innovate. Innovation is actually maybe more mechanical in a way than people might realize. And a lot of ways good companies innovate, and many times as a patent attorney, we get invited to a whiteboard session at a company. They've got a problem. They actually invite us sometimes to sit in on some of their brainstorming sessions, because sometimes we know the landscape of where they can go in a technology sense better. So, so how do good companies innovate? Well, they understand the market. They understand their competition's products and innovations, okay? They look for ways to offer improvements, design alternatives and competing products, and they foster a culture of creativity. To me, that's a lot of platitudes, and there's some more practical ways, kind of where you start. Where do you start when you want to start innovating? So you got to look at typical sources of information. So what companies do is, they get the product literature from their competitors. They know their competitors' products very, very well and see how they're tackling problems, right? They look at white papers. They go on the internet, they research papers, depending on what you want to do. They look at trade journals. They go to trade shows. I go to trade shows. Sometimes my client wants me to do a little walk around and see what the competition's doing, and I might want to go and see what their products are, because sometimes I report back and say, yeah, I think we can sue them. And so we do go to trade shows, and a lot of times, trade shows, once that trade show shuts down, and you might remember this if you're the young engineer running the trade show, when that trade show shuts down and everybody leaves and the equipment's just left out there in the open, sometimes there's inspections going on. I was involved in some California litigation where the other side had inspected my client's equipment in the middle of a trade show, and apparently it took place after hours. So they do reverse engineering. They go and they get their competition's product and they take it apart and they try to see, how did they do? And a lot of that's happening a lot these days. One of my clients, Faro Technologies, makes a laser scanner that's mounted on an articulated arm, and it can scan very, very precisely. It could scan that bottle to the precision of 35 microns, which is about 0.001 1/4 inches, I've been told. But it can measure very, very, very precisely. So now with the technology that's available, it's very easy to reverse engineer to a very, very high level. Now the other thing they do is they look at patents and patent applications. And I want you to think about patents and patent applications as you start your MQP in terms of trying to get ideas on how to design things, because they're a valuable source of information you can go to see what's going on in your particular design problem. So where do you get them? There's a lot of available resources, and they're actually free. Google Patents is actually fantastic. So if you type in a word search in Google Patents, many times you can bring up some very relevant patents. And once you find one relevant patent, patents are actually sorted by category and class. So when you start to figure out, okay, what are the applicable categories and classes of patents I want to look at, from my word searching, you can go back and start doing some searches by category and class. The U.S. Patent Office, which is www.uspto.gov, you can do your own patent searching right there for free. And a lot of times, we represent some of the larger companies in America and in the world, and they are very, very sophisticated in patent searching and hire counsel and have in-house counsel. But a lot of times, smaller companies and maybe individual inventors, a first pass before they even contact counsel about an invention is to do some searching themselves, so they avoid spending money where they don't have to. I'll give an example. I have a neighbor who invented, so he thought, a battery backup for his garage door opener. He said, there ought to be a way to keep electricity in your garage door opener when the power goes out. And I said to him, Jim, that's a great idea. I said, but while you're selling real estate in Hartford, there are people that work for Craftsman and other companies that make garage door openers that are thinking about these problems all the time. So go on and do some searching just to make sure you're not starting in a place where you're way behind. And sure enough, he did some searching and found out that the battery backup for the garage door opener dated all the way back about 40 years. So what we try to get from patent analysis of patents and patent applications, there's really two types of reports we look at. We look at state-of-the-art reports where we can find out, well, what are people doing right now? It gives you a very good snapshot of what are people doing right now in a particular design area, okay? And then you can do some themescaping and some patent mapping to see where the trends are. And sometimes, in a really complex commercial environment, patent attorneys are involved at a very, very high level in what we call freedom to operate opinions. So if General Motors is going to have a new car with all these new systems come out, most often patent counsel is very involved in that process because they're making sure that each aspect of that vehicle is free to operate away from someone's patents. And I've been involved in quite a few freedom to operate projects. They're kind of fun. Sometimes you get flown to look at the equipment. Sometimes they mail you samples of the products. And then we start a process where we try to determine whether there's freedom to operate. So what I thought I would do, so the way you can get into this, and this kind of comes to your design criteria, is, you try to do a similar strategy as to what you do when you design. You're going to identify the customer's needs. You try to do some filtering with the IP landscape. Now, where do you start? Well, if you're working for General Motors, you better start looking at Toyota's patents and BMW's patents. If you're looking at steam mechanisms, you have an idea of who you should start looking at. And then you're going to, start to filter, try to figure out, is there an open space here where we can aim? And I'll give you a practical example in a minute. And usually once you kind of figure out where the open space is, then you can try to brainstorm ideas to try to fit that open space. Then you got to kind of go back and say, well, are there any patents that are within these new ideas that we have? And you'll brainstorm some technical solutions. And once you get there, once you have a solution that you're going to design, then you can consider too, well, not only are we avoiding everybody else's patents, we can look at maybe patenting and protecting this ourselves. The second part of my talk is going to just introduce you a little bit to those concepts. So I thought, I was trying to think of something that's really simple. for you mechanical engineers. I mean, once you go to law school, you kind of forget about mechanical engineering, but I was thinking of a paperclip as an example, and I've given this talk a few times before. I'll ask you some rhetorical questions. Is there innovation going on in paperclips? You know, you've seen them since you were a child, right? And can we use patents and patent applications to find out something about the state of the art and the technical trends for paperclips? And the answer to this is yes. I did a little bit of design criteria for this, and I said, well, what are some of the customer needs? Different paper thicknesses. You know, have you ever tried to, throw too much into one type of paper clip? Inserting multiple papers, tears, retaining strength, joining papers together. And I did a little patent search, and I wanted to know, okay, what's the state of the art in paper clips? So what I found out is, yes, there's quite a few new paper clip patents being applied for. And, and to address different thicknesses, you can see they have a bigger, thicker hinge. They've got a new force retaining member here to retain the paper a little stronger. Here's another, type of hinge. So in my brain, I said, okay, well, one thing people are doing in paper clips is they're trying to improve hinges for larger paper stacks. Something I concluded from my little patent search. Then I looked at different paper thicknesses from another angle that inventors were looking at, and that was with wire geometry. And so here were some wire geometry patents where they kind of fiddle a little bit with the loops that you're used to try to thicken the stack. And then multiple papers. Someone has come up with this concept of having multiple loops. These are two different patent applications by two different people. And you can see this one is pretty recent. This is from 2011. So people are out there trying to patent paper clips. Retaining strength. Here's another one, retaining strength. And so they're trying to address the problem in different ways. And then this one was my favorite because we're all trying to get to green technology. And in this example, the inventor decided to make a paper clip out of compressed fiberboard. So you have a recyclable paper clip, but you also have one that's made out of a recyclable material. And you can see the little illustration here is how it would work. It has a little cutout, so through the force of the compressed fiberboard, it kind of holds it together. So I know what the state of the art is. I know what people are working on. So what do I do with that information as a design engineer? So if I look at the patent landscape, I quickly find out, boy, I've got different profiles. I've got different hinges and jaws, wire geometry, materials, and then I have green technology. And then I can target the open space. I can figure out, okay, where can I go? Well, I only found one patent when I did this a few years ago on green materials. So I can look at green technology as maybe that's a trend. If I wanted to invent a really decent paperclip, I could think about green technology. So then, well, let me talk about some of the advantages, and then we'll talk about protecting it. So what are the advantages of using patents and patent applications as part of the design process? First of all, it helps you uncover recent innovations. Now, companies maintain active patent searches on their competition. Why? There's a lot of reasons for that. One is they want to make sure they don't invade their patents, but they want to see what they're up to. And sometimes patent applications are a very good indicator of where the products are going to go for the competition. So discover the competition. Determine industry trends. Whereas everybody is looking at using an absolute distance meter with this machine. It also helps you monitor potential blocking patents, and it creates it fosters a culture of creativity. Why do I say that? Because, all right, now we know that people are messing around with loops. We know they're messing around with compressed fiber. Gives us some ideas of maybe what we could do around the blackboard to try to think of some other inventions. And then it helps us also develop IP. So kind of review, identify the customer needs, filter it with some IP landscape, brainstorm some solutions, identify open space, develop a technology roadmap, and then develop products and IP that you can protect. So I often am asked to say, you know, what's the most important form of intellectual property protection? People invariably say, oh, a patent, because they've heard of the patent. But in reality, patents, well, they're great because they protect, you know, new, useful inventions, whether they're a design patent or a utility patent. They take a long time to get. The average time to get a patent in the United States is somewhere between 3 to 5 years, and 5 years is not uncommon. So once the invention is applied for, what happens? It goes down to Washington and it sits for several years because it's a bureaucracy and they've got a lot of other patent applications in the queue to look at. And so it's not as effective for business sometimes. It's effective to file the patent application so that with the hope and expectation, someday the business will get a patent. But it doesn't happen instantaneously. It's not like a copyright that attaches. You know, you're back in your dorm room or your fraternity at SIG Up and you're writing a nice song, you know, and as soon as you're done that song and you've recorded it, you have a copyright interest in that song, okay? A patent takes many, many years to get, and then if the company is going to seek international protection, that patent goes to a whole other patent application through the International Patent Cooperation Treaty and goes overseas. And that whole process can take 5 to 7 years. Last summer, I litigated a 2-week trial against Nikon Corporation in Boston, and one of the patents that was at stake in that case had issued in, I think it was 2005, on an application that was filed in Britain in 1995. So there's a big time delay. So it can be very, very expensive to get patents, and it can take many, many years. So the intellectual property agreement is probably the most important form of protection that a company has at the beginning of a project. And I say that because one of the first intellectual property agreements you're going to see as an employee in most companies is going to be an employment agreement and a non-competition agreement. And there's some limitations in the state of California and some other states on non-competition, but I hire you, I train you, I teach you about our secret process for making steel. That doesn't mean you get to take that information and walk down the street with a competitor and say, hey, you know what, I work for company A and I know how they do that secret process for steel. So, so that's a very important agreement that a young engineer, she will see, you know, almost immediately when she's retained, especially by a big company. The other type of agreement is a joint development agreement. I've got this great idea on new ball bearings, and I've got to treat them in a special way. But in order to treat it a special way, I've got to send them out to this company that can clean them and then add this treatment chemical to them. And I have to tell the company how this works in order to have it done correctly. So I'm going to need a joint development agreement where they say, I own the intellectual property, and it's a secret, and they're not entitled to let it leave their building, and that they'll take reasonable steps to make sure my trade secrets or our trade secrets are not disclosed. Non-disclosure agreements are also very, very common. Many times, non-disclosure agreements are exchanged between parties. They're so common that lawyers are often not even consulted on them. Once a company has a standard non-disclosure agreement, they exchange them, and basically that agreement says, hey, I'll tell you about my secret sauce, but you're not going to do anything with it. You tell me about the chocolate chips you'll put in the secret sauce, and together we can make some chocolate chip cookies, but if this deal doesn't work out, you're not going to show anybody, my secrets, and I'm not going to show anybody your secrets. You'll own your stuff, we'll own our stuff. Ownership agreements, this is especially critical in software copyright issues because unless the copyrights are handled correctly in software, the person who drafts the code owns the software as opposed to the person that hired the company to draft the code. And you have to be very, very specific about the contracts to make sure that that goes. And then license agreements are very common where, I've got a patent on this, I don't have the resources to make it, you can make it, you pay me a royalty on my patent. So we see a lot of, and you've seen software licenses when you've loaded or download software and Apple asks you agree. if you're like most of us, you just say, why do I need to read all this? Can I just hit agree and get it on my computer? But there's actually a reason for that, and that's because you're entering into a license for that software. So the IP agreement, the intellectual property agreement, is important because it can cover just about anything. It's flexible, it can be customized. It's expedient, as I said, because a patent costs tens of thousands of dollars just to get the patent. It can cost hundreds of thousands of dollars to enforce a patent. And it can provide for additional protections such as warranties and representations and risk allocation. So the key to success here is to do due diligence. Make sure you do freedom to operate. Make sure that you know who's going to have the rights to intellectual property when you enter into a business relationship. Have a well-drafted agreement because, as I say, you can apply for that patent, and I think there are a lot of advantages of that because people apply for patents for a number of reasons. One is because if you have a lot of patents in your name, you're elevated, I think, to a higher status amongst your contemporaries. But more importantly, a lot of times, if a company has some patents pending, even if they don't have the patents yet, it's a little easier for them to go to New York City or Palo Alto and get some venture capital to come into the company because the venture capital individuals will know, hey, look, these people are serious, they've got some IP protection on it, and if it's good, they know that they can even take that application and bring it to the next level. And often, in most instances, things have dual protection. So, you show up at the company, you sign a non-competition agreement and an employment agreement. You also usually typically waive all your rights and any inventions to the company. They're automatically assigned to the company. The company then, if they show your invention to another company, gets a joint development agreement or a non-disclosure agreement. At the same time, they apply for a patent. If there's software to it, they'll probably protect the software. So there's dual protection. So when I say due diligence, typically, what we do is we make sure if the individual says they invented something, we try to get some kind of evidence as to how they invented it, that they truly were the inventor, that it wasn't in fact somebody else at a different company who invented it, and that they in fact stole it, because that gets litigated sometimes too, it happens. So sometimes we actually do an inventory. Sometimes we even get flown to companies to go through their records to establish who invented it. Patents give you a right to exclude. And the way a patent works is you say to the government, you say, this is how I did my invention, and in return for teaching someone of ordinary skill, this is the test, in the art to practice the invention, if it's novel and useful, the government is going to return the favor and give you a limited monopoly on that invention, which is 20 years. Copyrights, cover a mode of expression. So as I said, the song you wrote or the artwork you drew, but also many times, copyrights attached to computer software code. They attach to the presentation of web pages, the content. So the copyright is a very, very important form of protection. And it's longer. It's the life of the author plus 70 years. A patent now lasts 20 years from the date of filing. So let me give you another little twist here is trade secrets. So if somebody's treating steel with a special process or a plastic film with a special process, that you can't reverse engineer. So one of the things I've hired Professor Sisson here to do in some of my cases, I say, I want to know what's in that product because I want to know if it infringes a patent. So I get a sample of the product, and we kind of keep a little chain of custody, and then the professor or the expert will take those samples, and then they will analyze it, and they'll do glass spectrometry to figure out what chemicals are in it. They'll look at the crystal structure, because now I have an expert who can tell me before I file my lawsuit, yes, that porcelain has the elements that are in the patent claim. And I have to lay that foundation before I can bring a lawsuit. So that's how lawyers and professors interact with each other. We like professors for another reason, and that is because when you try to explain to a jury how a laser works, or how the processing of the laser does the centroid processing, where it determines, through a calculus equation what the brightest pixels are in the laser, that's a pretty tough subject matter to explain to a jury. And professors are usually great expert witnesses because they're used to teaching, and they're used to trying to take people from a very low level of understanding to a higher level of understanding. And what we hope is by the end of the case, the jury will kind of get the picture of what the case was about, because in that one narrow subject matter, they're going to school 8 hours a day for 2 weeks, and we hope at the end of the case they understand what the case is about. So trade secrets are important because if to get that patent, you have to disclose to the patent office what you invented. And the hope is that you'll get a patent on it, but that doesn't always happen. And people can then read your patent and design around it and innovate from your patent, just like in our paperclip example. So if something is very, very hard to reverse engineer, i.e. you can't take it and do, gas spectrometry or put it under a microscope and figure out, how does it really work? Well, sometimes that type of technology is best suited as a trade secret because nobody can ever really figure it out completely. Now, gentleman in the back is drinking some Coke. Well, guess what? That's one of the longest held trade secrets in the country that I can think of as I'm standing there. That's because the trade secret of how you actually make Coke, how all the parts come together, is under lock and key. So, so it's interesting. Trade secrets can be very, very valuable. There's some requirements. You have to, it has to be kept as a trade secret. We get into litigation sometimes where ex-employees try to take trade secrets and then use them. Most states have a Uniform Trade Secrets Act, which you might not be aware of, and it requires individuals not to steal trade secrets from companies that they work in. It's pretty much enforceable in every state. Trade secrets usually have to have some sort of security infrastructure attached to it. A lot of corporations have you sign in when you visit them. You'll see that in your careers. Or they'll have certain portions of the facility that are under lock and key. I had a funny situation in a case where I had the right to go inspect the facility to see a certain manufacturing products in the facility. And they were so nervous about a bunch of lawyers and expert witnesses walking through their facility, they got somebody to install all these black drapes so they could block off the rest of the factory from our prying eyes. Usually the employment agreement, the development agreement, is going to be added onto that. So trademarks, you've all seen, different trademarks. They can be associated with a symbol or a word. But there's another interesting aspect, and that is trade dress. Now, there's a reason why Pepsi can't sell its soda in a bottle that looks like a Coke bottle. And the reason is because in 1911 or so, 1909, Coke applied for a design patent on its bottle. And now the design patent only lasts 14 years. But during that period of time, Coke developed trade dress rights in its design that are enforceable so that somebody can't copy their bottle and put soda, a dark colored soda in it, because they have the trade dress rights to the shape of the bottle. And that's why in the automotive industry, you can't start making Ford Mustangs from the 1960s because Ford has trade dress rights into the look of those cars at this point in time. So the other aspect that we get into is counterfeit goods, because counterfeit goods is a $650 billion industry. So there's a lot of, and I'm just going to conclude with this, there's a lot of intellectual property issues with counterfeiting goods because we have to try to stop them at the border or stop them at the source. Sometimes that means engaging in the work of overseas attorneys in Russia, even attorneys in China. So it can be very, very difficult to pursue that. So in a nutshell, there's two aspects of patents in any design project, I think. One is using them effectively to start the design process and knowing what's out there, doing freedom to operate, because you would have to ensure that your invention is not going to impinge upon somebody else's IP. And then the other aspect is once you've got your design locked down, how are you going to protect it? Are you going to you're going to probably need some agreements if you're showing it to third parties, but then you need to think about whether or not you should apply for a patent. So that's basically what I was going to cover today.